I'm George Whipple, one-on-one with Jeb Gerth. Jeb, you're a litigator.
That's right.
And that's really what you do. And you have courtroom experience in ERISA. When we have an ERISA issue, I'm not an ERISA expert. We've got great people that know ERISA, can set up those plans, can manage those plans, can update those plans. But when we're doing that, shouldn't we also have a litigator like you as part of the team that knows how those plans are going to be interpreted in the courtroom? Because at the end of the day, that's what counts.
You're absolutely right. One of the great things about Epstein Becker's ERISA practice is we've got ERISA compliance lawyers that are second to none. What a litigator does, it's a different perspective that's complementary.
Right.
Compliance is all about design and best practice. Litigation perspective, in my view, a lot of ways is a stress test. It's looking at a plan through the eyes of that class action counsel. Because when it comes to litigation, as a defense attorney, most claims, ERISA claims, are not based on actual noncompliance. They're based on the perception of noncompliance, or maybe more cynically, the set of facts that allows a creative and skilled lawyer to argue noncompliance. And so what a litigator does is bring that perspective.
These cases, to my mind, these are real threats to the company, aren't they? Aren't there huge judgments that can result from these type of class action cases?
Yes and yes. They are very similar. In fact, a lot of the firms, the plaintiffs' firms that are doing ERISA class action cases started out doing FLSA, wage and hour collective actions.
Right.
And yes, because of scale, they're expensive. They can be expensive claims. And class counsel, ERISA, like the FLSA, is a fee-shifting statute. And so the attorneys that bring the case, if they prevail, are going to get paid. They're going to get paid by the company. So you've got the scale of a class claim and the prospect of attorney's fees on top of it.
So specifically, when you're working with the lawyers that are creating the plan or updating the plan or reviewing the plan to make sure it's compliant, what specifically does a litigator do as part of that team?
One place a litigator will look is where are those places in the administration of the plan where someone or someone's, a committee or an individual, is exercising some discretion, where a duty of prudence arises, a spot where someone might come along and challenge what happened. And so if we're talking pre-litigation, 2 years from now, as you know, once we're litigating, the facts are baked. While the plan is being administered, we're making the facts. And so a litigator's perspective allows you to say, okay, what would we want in documents? Number one, that, in my view, reduces the chance of litigation because it's harder for someone to poke holes in it. And number two, if there ultimately is a lawsuit, you're litigating on a set of documents that is favorable to you. I think anywhere in the claims administration process, from an individual claim, and again, that's we think about that as a onesie. That's George Whipple making his
on
claim.
The phone going,
right.
Why am I on hold for 30 minutes?
But whatever happens there, that may be indicative of an issue that's broader that someone might try to exploit, especially where there are tells that maybe something's going on. So Mr. Whipple calls his plan administrator and says, that may be what the plan says, but I was told that I would get this benefit.
Right.
That might be a signal, okay, something's going on. There might be an opportunity to clean that up before it goes further through the process. And now, in the plan and the company risk litigating a misrepresentation. I think a third place that a litigation perspective is helpful is when ERISA allows participants and beneficiaries to ask for documents. If you don't have a copy of the plan or the summary plan description, you can ask them to get it. And if you don't get it, the plan's subject to penalties. Smart plaintiffs' lawyers will use that as a pre-litigation discovery tool. And you can see that sometimes. And so sometimes there's a tell in the request for documents, even if it doesn't come from a lawyer.
Yeah.
It sounds like it came from a lawyer. Right. And so there's another opportunity to say, okay, there's something going on that could be, that maybe we could get ahead of. And in the best case, avoid a claim in litigation. In the worst case, be ready for it.
And that's what it seems to me you bring to the table, which is while we're administering these plans, while we're building these plans, maybe we put on this bell and whistle that is not legally required by ERISA law, but will be helpful when we go to defend this plan in the courtroom.
Absolutely. I think that ERISA plans are technical, and they have to be technical, and they have to be integrated. The case is going to be presented by a plaintiff through the eyes of a plaintiff. How was I supposed to understand this? Was it treated fair in the way this is drafted? And I think that if you've litigated that, if you've had to explain that to a judge that looks at ERISA cases fraction of his or her time,
and the eyes may glaze over a little bit at the technicality of ERISA.
Right. But if you can take the technicality and simplify it to concepts that make sense, and then ultimately show that a particular person or a class of people was treated fairly by the plan, that's the goal.